Welcome to the Iowa RIA and Iowa Landlord Association, where we educate, advocate, and empower real estate investors.
So welcome to our monthly meeting. I'm sorry I missed last month's meeting, but I'm 95% of the way back. This is day 36 post-COVID for me. And it took a while, but the energy level is back up high, or at least just darn near where it was. And I don't know if anybody else has had the experience or not. Anybody online had the COVID?
Not yet.
Not yet.
I had a quote virus for 3 months before COVID came. Right when they got ready to lock everybody down, I was getting ready to be able to go out.
Did you get tested then, though?
No, I didn't, because back then when they first started, they didn't have the test to test it. But my doctors and I both think that's what it was. And we're just assuming it is. If I have any more symptoms come up, they'll test me. But yeah, it was just called a virus then, but it went on for 3 months.
Wow. Yeah. My son might have had that last year too, in like January or something. But until you've been tested positive with it, you just don't know for sure, because there are other viruses that circulate. But the thing is well, for instance, like this week, I learned from Mary Davis up in Cedar Rapids that one of the past trainers for the Iowa Real Estate Commission, and primarily probably Iowa Association of Realtors, was a gal named Judy Stevens. And she'd been around for a long, long time, a good trainer. In fact, she was training up in Marion when we had a training session with Christopher Warnock at the Kirkwood Community College. I know Pat was there. I don't know if anybody else was there, but she came across that open area and came up to me and said, "Gosh, what are you guys doing here?" And I said, "Well, we're training on Iowa Code 562A." And she said, "Gosh, I wish I was in that class." And but she was the primary property management trainer for the Iowa Association of Realtors courses, and she passed away. She and her husband both died with complications from COVID. So she was a long-term trainer, and if anybody was ever a real estate agent, you probably had her for a class. She taught a lot of them. But she's gone. So in a way, that kind of opens something up for us, and so we're going to double our efforts to try to get back in the saddle on doing some training. And Kim's been working on that diligently this last couple of weeks. We're looking to add instructors, and we actually have something on the schedule, so we'll talk about that at the end. But
Andrew, the person that was featured in the National RIA magazine earlier this year was also up there. I think he's from Altoona.
He was also up where?
At the meeting you're referring to.
Oh, Craig Campbell?
Craig was up there.
Oh, he was.
The two of us was there.
Oh, from the Des Moines area. Oh, well, there were, I don't know who else was there, but that was just interesting, because if you examine the educational offerings from Iowa Association of Realtors, 95% of what they offer to people, that they provide CEUs all the time, continuing education units. But if you're a realtor, 95% of you realtors are interested in listings and selling property. There's very, very few of them, about probably 5% or less, that are interested in property management. And yet the state has seen fit to require third-party property managers to have a license. If you accept checks in your property management company's name, you for sure need to have a license. And and they also want you to be full-time, which I think is really bad. In fact, that's something I should write down. We get that question quite a bit. Is a landlord allowed to hire somebody on a part-time basis to manage their property for them? How many people believe they know the answer?
Well, aren't they supposed to be allowed to do whatever they want to, how they want to manage it?
Well, that's part of the question. Should landlords be allowed to hire a person part-time to manage their rental property?
Yes, we should be allowed.
Okay, and what triggers you to be protected from any admonishments from the Real Estate Commission for having somebody practice property management without a license? How do you get around that requirement?
Our property manager has a real estate, they've got a real estate agent that works for them. So I assume they're covered. If not, our contract makes them responsible.
Well, one way you do it is you put them on a W-2. They become a W-2 employee. If you're paying their wages as a W-2 employee, then they're covered by the fact that they work directly for you. They're not an independent contractor. And are you going to get called on the carpet? Not very often, but we've had people that were members that actually got called on the carpet by the Iowa Real Estate Commission because they were offering property management services, but they didn't have a broker overseeing their operation. Even though you're a licensed real estate agent, if you're not a broker, you can't accept rental property money from a landlord or from a tenant with your company's name on it. So that's a little esoteric thing, but the point of that really was that it's an area I'd love to see changed, but I got to remember to write that down, and in our voluminous spare time, we'll get that done for you.
Well, that goes against, I mean, I know they don't care, but that goes against a lot of the quote gurus out there that are teaching people to open their companies so that they're just like them and their spouse. And if they have their retirement account set up in a self-directed solo 401k, then they can't have W-2 employees other than their spouse. So that's,
oh yeah, I could see that would be true. Mm-hmm.
So that throws a problem into that.
Okay, well that's a good topic for another time. Self-directed IRAs, and
I don't know if it does for all of them, but we have ours set up in a self-directed solo 401k. And that's part of the rules, is that we can't have any W-2 employees other than me and Tom.
Okay, well,
whether that comes federally or what, but that was one of the things that we very specifically were told, and it's in our, I want to say charter, but that's not the right word. It's in how the company is set up.
Kind of like covenants and restrictions or something.
Yeah.
Yeah. Okay, well, let's go down through a little bit of this general business, and by all means, raise your hand. You down below, there's actually a raise your hand option, I think, and there's a chat dialogue. I think. Do we have a chat room on here? Yeah, we do. I'll put that up so if anybody wants to just type in a question instead of repeating it, feel free, and we'll try to address that. But let me just start with National RIA is doing an eviction moratorium survey, and they want us chapters to help with acquiring the data from landlords and property managers as to whether how it's impacting you. And so we're going to combine that though with our legislative priorities. We'll add that to part of the survey and hopefully kill two birds with one stone. But do keep your eyes out for that, and it's probably got to be by next Monday or Tuesday that we'll send it out. We've also joined the National Association of Professional Process Servers. That's because we were just bored to tears over here and didn't have anything to do. So we thought we'd try to complicate our lives even more. But that's not really the truth. That's tongue in cheek. And the reality is the reason we joined is because just like you folks, if you join an association, you want to get some shortcuts, some tips, and some tricks that will help you to be more effective in your business, more efficient. Well, that's what we're doing here. We want to be very effective for our members. Of course, it's a potential revenue stream for us, but I think it keeps us more up to date and really in tune with what the requirements are for proper service, legal service. And so that's something like I said, we've recently done. We've already had 3 different process server requests from out of state people. I don't expect that to take that much of our time for working some of that, but you will find us listed there as a member of that association. And what does that mean for you? Well, hopefully it means that you'll be able to get better services when you ask us to do anything at all to do with legal process service. I'll just mention CIC because I know there's some people sometimes on the call that are not working with CIC. All members can be on this program for tenant screening, and we waive the fee for registration. I still find people today who are not doing thorough tenant screening reports, and it just makes me shake my head. Don't understand that, particularly when you can have the tenant applicant paying for the cost of the tenant screening. So we'll beat that horse again another time too, probably, but it's so important. I think in today's world, I deal so much with the tenants who are not performing well, and it of course is driving the owner of the property crazy while they're still in the property. And there are times when you can avoid all that just by saying no to somebody that you might otherwise say yes to. Now, some of you may have seen the announcement from the City of Des Moines that they were funding 2 groups. They're funding Home Inc. and they're also funding Impact with $500,000. Now that's a whole lot less than what the Iowa Finance Authority had. I think they had 10 or $11 million. But it's just another source, and they will fund up to 3 months worth of rent for people. And of course, there'll be some qualifications, but you could call Home Inc. or call Impact if you think you have a tenant who might be eligible for some COVID funding relief.
Andrew, I can't find to raise my hand, but I just typed it in there. I heard on the news last night that that money is all gone. They had too many people apply within the first 4 hours.
Well, there you go. Hey, I'm glad I had you on the call so we could get that squared away. Oh, well, Tim Wilson, who spoke a couple months ago, probably still has access to resources. And the Iowa Finance Authority, Iowa Housing Finance Authority there, they may still have funds available. But we're getting down to the wire now on because we're hopefully at the end of this month, we're going to see the feds pull back on this eviction moratorium. But anybody hear any news though on that? I think there is talk of extending it, and they've already extended it for people that have federal loans. It's already been extended to January 31st. But nothing definitive yet on it. And then I'll just add it that we're moving this office to my house. Just like 9 years ago when I first started working with the Iowa Landlord Association, the RIA group had worked out of my real estate office. But then once we took over management of the Iowa Landlord Association, we moved to a bricks and mortar location, and some of you have been here before. But one of the things COVID teaches you is that a lot of us can work from our homes and not incur the costs of a commercial lease. So there are some people today that are probably hurting a little bit more than they were previously, who are commercial real estate investors, because so many business people have discovered, well, we don't need this much office space anymore. And that's what we've discovered too. Then the last thing is that we'll probably be sending you a kind, soft invitation to donate to our PAC fund. Funds have been diminished greatly. We haven't really done much for promotion of that, but we have some time yet before January 11th comes to potentially try to make sure we have a seat at the table, and donations will help. So keep your eye out for that. Okay, then other than that, anybody have any questions on any of that? And Linda said, yeah, the 500,000 is already spent. Wow. Within 4 hours is what you heard?
Yeah,
Wow.
they said there was over 200 people applied in the first 4 hours. And they said that the money was already spent.
Amazing.
Said on the Channel 8 news last night. They're looking for more, but I'm sure they're always.
Kind of word spreads fast.
Oh, yeah.
Yes, it does, especially when they broadcast it on KCCI TV or on the news at night with the other ones too, WOI and WHO. Okay, so I'll make this part fairly brief. I just want to bring everybody up to speed on the fact that we had an election, and we're still having an election on some things, but I think all of these races were decided probably within the first 24 hours. I don't think we had anything nearly as close as Iowa House U.S. District 2. But what's happened is we have 59 Republicans and 50 or 41 Democrats, which basically means that bills must be sponsored by a Republican to be picked up by a committee. And that's okay, because we've made some friends over the years with people in the House that are on both sides of the aisle. In the Senate, we're still holding at 32 Republicans and 18 Democrats, which also means bills must be sponsored by a Republican to go anywhere. And last year we had a bill sponsored by Brad Zahn, and I'm hoping we'll be able to get the same thing done this year. But the point of that is it's coming up sooner than we'd like almost. It's what, a week and a day from, a month and a day from today, January 11th. And so we've got a lot of work to do in the next 3 to 4 weeks. And what kind of work are we talking about? Well, in the landlording business, everybody knows you're either playing offense or defense, but you're playing it all the time. One day you're doing something offensively and trying to keep ahead of things. The other time you see this big steamroller coming at you and you just try to stay out of its way. I can't even begin to fathom how difficult it is in today's environment if you have tenants who are not paying the rent and you can't evict them. It's just unconscionable. I personally can't even understand it. but I have done this. I have watched what's going on in other states where they're suing their state governments. And I can't watch all the news all the time and keep up to date on all of it, but I haven't heard of a single case where they made any progress. Has anybody else?
Andrew, last night on the news, there was Jim Conlon's son, who apparently works in business with him,
Yes.
said that 25% of all of the tenants that they have are not paying any rent. 25%.
Yeah, and that's a JD or B. I think it's JB. Yeah. We actually visited about that, a few months ago when that eviction moratorium first came down. But yeah, 25%. And you're talking about an entity that has, they didn't say how many thousands of units.
They didn't say, but they got a lot.
Yeah, the last time I heard it is they owned at least 3,000 units and they managed another 3,000 units. It's one of the largest, and Hubble, of course, is very, very large, as is the Levi group. What is it, Newberry? I think Newberry. But these are huge landlords that are 25% of your revenue. Hell, you're probably lucky to, in a good time, to be able to have 10% flow through on your P&L statement, maybe 5%. But if you take 25% right off the top of the most important line on your P&L statement, the revenue line, I just can't imagine it.
They would be in a negative cash flow pretty fast at that rate.
It just seems to me that it's just a very odd way to try to cure a problem, and balancing your books on the backs of rental property owners when all the time we hear about how important it is that there's affordable housing available to people. And yet they're driving the people out of business, or at least seems like they're trying to, out of business, and driving them to other kinds of investments. So with that said, let me just say we're going to go back to the table with a date of birth redaction issue. We get resistance from the Iowa Association of Magistrates, the Iowa Bar Association, the Attorney General's Office, and the Iowa State Supreme Court, the judicial branch. But we shouldn't be getting resistance, because if you go to Iowa courts online, you'll see dates of birth many times listed there. I personally think whenever you file, do an e-filing, you should put the date of birth on the record so that the people that follow behind you can do an exact match. And what this issue is about is actually started about 6 years ago, where the judicial branch and the data processing part of the judicial branch said, we're not going to transfer exact data to companies like CIC or other tenant screening companies. And the way I understand it, I have yet to nail somebody down on it, but the way I understand it is they just transfer the year of birth. They don't send the month and the day along. So as Pat walked up to me one time when we were doing a legislative day on the Hill and said, how come these criminal activities don't appear on my CIC report? You remember that, Pat?
Yes, I do.
Unfortunately. Well, I didn't have a good explanation, but today we do. And the explanation is that for some reason, the Iowa judicial branch has seen fit to withhold the month and the day of birth, but they'll transfer the year. So if you have somebody who has a common name and all you have is a year, you may not get an exact match. And so you don't see any criminal activity on a report that, well, maybe it should have like 10 or 11. I have one right here that I keep handy because this is my example. And these were the different addresses the party lived at. And that was the only way we really caught the gal. But on the report, it said, no evictions found, no criminal activity. And yet, if you go to Iowa courts online, there were like 11 of them. 11 different entries. So what I'm saying is this works against the industry. I also think it works against tenants, because when somebody goes to the Iowa courts online and you do a search, you're going to spend a lot of time trying to figure out what data you're supposed to be allowed to look at and the other data that you're not supposed to take into consideration.
Andrew, that happens a lot. And for everybody that uses CIC, and I sent 3 of them over in the last week or so, you've got to also go to courts online. You just cannot take CIC only without going to courts online. You just cannot do it because they do not have all that information.
Yeah. Yeah, I've actually I asked Dan Firestone, okay, well, what's your solution, Dan? He said, well, because your state's so, and this isn't the only state that's like this, but because your state has made this decision, we can't get accurate information and we can't give you a false positive under the threat of an amazing amount of liability. You can't have an entry on a credit report for criminal activity that's not valid, because somebody could be, you could deny them the right to rent because of that statement. So they can't risk it. But I beat on that dead horse before. It's a very, very major issue. But hey, this time maybe we can get a little momentum going on this thing. Next thing, bill to counteract Meyerson versus Meyerson. What is that? In a FAD proceeding, if the plaintiff walks into the courtroom and hasn't had every single T dotted properly or crossed properly and every I dotted properly, you all know it's very easy for them to dismiss the case. In this particular situation, the legal aid attorney that was representing the defendant did get the defendant to the court case, and she appeared before the magistrate on the day of the meeting. And as some of you may know, there was a law passed that Megan Jones up in District 2 in Northwest Iowa, got the law passed that if your defendant shows up in the courtroom, well, obviously, they've received notice. They've received notice. How else would they be in the courtroom if they didn't know this was happening?
That is called common sense.
It is. And Megan Jones got it passed. But what can happen is the magistrate will say, well, now, did you have those full 3 days before this hearing took place? Well, no, Your Honor, you didn't. I just found out about it 2 days ago. Well, then you have the right to continue this case. And so I'm going to continue it for you. You need to have more time to prepare yourself, don't you? I mean, it's just so lopsided. It's just crazy. So in this case, this actually was not used properly, because this case is about contract law. It was a real estate forfeiture issue, and it wasn't even pertinent to the case. But you know, if a legal aid attorney can convince a part-time magistrate that it's true, can they decide against you based on law that's where they're inaccurate? Absolutely. It's just sad. It's just sad. So the only thing about this is that I will try to get Megan Jones to sponsor that bill, and we'll see what happens. E-filing agent, I won't belabor that. This is just a cyberspace Scrivener issue. We've had that going on for 3 or 4 years, 4 or 5 years, where people come in, they use our services to help them with the computer part of it. There are 2 states, Arizona and Washington, at least 2, where there is a person who is a licensed legal document preparer that's authorized to provide those services, particularly in small claims court. And it's a very positive thing for the industry, I think. But once again, we have a lot of adversaries, particularly in the Iowa State Bar Association. It would cut directly into the revenues of some attorneys. And so they kind of have a monopoly. And we could approach it from a Sherman antitrust point of view, but we'd need to have a lot more money in our coffers for that kind of a challenge. But we'll see if we can gain momentum there. Self-help for landlords. Some of you may remember that Alan Suby is the champion of this bill, and it would basically do things like allow you to install your own water heater if you like doing that kind of work yourself, or even if you don't like doing it, but you got the call on a Saturday morning and says, hey, the water heater's out. We need it right away. We've got 3 kids and we all have to take warm showers and blah, blah, blah. We want to do our clothes. And so all of a sudden it's emergency. So now you have to hire a plumber, and you call the plumber to do it, and it's going to be double time because it's the weekend, And so this just basically opens it up so that some of these basic smaller types of tasks that aren't up to quite so much risk, like in installing a circuit, that the same inspector is going to come out and inspect the work, whether it was done by you or that was done by a licensed professional. If it's an addition of a circuit, if it's rental property, you can't do it. Seems goofy. There's a lot of landlords know more about the wiring than the electrician that comes to the site. They've done it maybe all their life, but right now you can't do self-help like that with rental property. Legal process service expand to allow service to employers. In some states, believe it or not, California, this is allowed. It's not allowed in Iowa, where you can serve that primarily, usually it's a defendant. You can just serve them at their place of work. Now, if it's a garnishment, they're going to serve at the place of work, but they're going to do it. You have to do it through the sheriff's office if it's a garnishment. I just think we need to work on this one. This is ridiculous. If you can't find the tenant and where they live, but you have their prior employment, you know who it is that employs this person, why can't you serve through the employer? Now, with all that said, you see, and this is the time when you guys can hit me with any questions. What am I missing? What are we missing here?
Andrew, to attach money out of a cash register for a business, you also have to use the sheriff.
Right, which is like a levy. You can levy at the bank, or you could levy. They can do that. What do they call it? A till
Bank,
levy.
same thing.
Yeah, same thing. If you want to levy against a person who is self-employed and they happen to have a retail store, that sheriff can show up and take all the money out of the till. Oh, it's not exactly funny for them, but hey, if they're running a bar or something like that, of course. Anyways,
the sheriff has to have a co-deputy along with them. They won't do it alone. They have to have 2 people when they go do that.
Oh, okay. One to keep their eye on the cash when they're transporting it from wherever they just took it out of the till to the car. Some might end up missing. Okay.
And you get a pay for 2 instead of 1 on that situation also.
And you get a paper on that, that says we've impounded money for you?
No, you get to pay for 2 people to provide the services.
But the cost, the cost of it. Oh my gosh. Yeah. Well, okay, so on the offensive side, that's quite a bit, but I don't presume to have insider's knowledge on other things. Like some of you may want to attack this issue from a legislative point of view, is how is it that we ever allowed the governor to make a proclamation that thou shalt not evict because of COVID? Well, we never did that because of other diseases. I just don't understand it. I don't think it's a hoax because I had the darn thing, for this day 36. I know COVID is real. The fellow there on my screen, Craig Witzel, he knows it's real too. The COVID is real and it does impact people. But if you're not directly impacted, I have no clue why they should be allowed, why the governor should be allowed to declare an eviction moratorium. Should we pursue that?
I think it would be hard to pursue because it would fall under emergency situations probably. I mean, I'm not saying that you shouldn't, but I'm just saying I see that as a very tough sell.
Oh yeah, even the smallest one of these on this list is a tough sell. That one would be, but I mean, a lot of people have mentioned that. How is it that the governor had authority to tell landlords, well, you have to take it on the chops, and we aren't providing it. It's fine if they're saying, oh, we're going to have an eviction moratorium and we're going to help you with those people, and that the people have to qualify. I mean, this was like across the board.
Oh, I know. I totally agree with the idea that it's not right. It's just, yeah.
Yeah, I don't know that the sentiment is strong to kick people to the curb. I'm not saying that. What I'm saying is that so many times government entities implement these solutions, which the money ends up coming out of the owner's pocket.
It's our taxes that are paying this money for the tenants to stay in our property.
Well, they should put them on like a temporary Section 8 or something. You know, like all of a sudden, okay, we're going to have this evictions moratorium, and anybody that's not paying, well, you're going to go on to a special program, but you're going to have to qualify for the program and show us that you actually lost your job, or, you know, you had a adverse thing to your income, or one of your family members got it and you've got to stay home now and take care of that child, or your husband or wife or whomever has it, or that you're having to provide services to like an elderly person. Some tie into why do you need this break? But I don't know that it'll go anywhere, but I just wanted to see if the sentiment is strong. If it's not strong, we got a lot of other stuff to work on.
Andrew?
Yeah.
I feel like it's really important, but I don't think you're going to get anywhere on it. So your time might be better spent on something else that might change something effectively.
Okay. Well, I do know there's some groups around the country that are suing the states. I wouldn't be in favor of starting a lawsuit. I do think that could be a waste of time.
You are hoarding.
A lot of people are doing that privately. I mean, some of the landlords, the larger landlords around the country, like I'm kind of surprised that Conlon's not doing it currently. But I need to make a note to talk to them because, yeah, I mean, I know you're right. They have all kinds of emergency powers, but those powers tend to be for like if you have war. You know, if you had a war, then I could see that. Okay, and if anybody else has something that comes up, by all means, send it over to the office and we'll take a look at it and see if we can flesh it out. Okay, so that's the offensive side of what we're looking to tackle. Then the defensive side. There's only a couple things so far that we're aware of. I'm sure there's more. There always is more. But one of them is the mandatory housing choice vouchers. We fully expect that to come up again. For some who may not know for sure what that means, that is just basically saying that if you have a property and someone wants to apply to rent it and they list their income and their income says, well, I have a housing choice voucher from the federal government. Section 8 is what it used to be called. I think it's still, people refer to it that way, that you have to accept that as though that were regular income. Easy for them to say, but our posture has been we're against it, and the reason we're against it isn't because we don't like people that are on Section 8 housing. I personally think it's a good program. You just have to know what you're getting into. And one of the things you're getting into is mandatory 1-year lease. You can't evict, you can't terminate the lease at the end of that term without showing cause. So there's privilege number 2 that you've lost. And number 3 is you have a double inspection. Now, some people may think, well, a second inspection isn't that big of a deal. Well, it's more of your time to meet someone there. They aren't going to go into place unless there's somebody there. You may have to coordinate with a staff person. It just is another hurdle to go through. Anybody else know of issues on this mandatory housing choice voucher and want to comment?
Yeah, I have something on the Section 8.
Okay.
On the other hand, if you rent it to a Section 8 tenant, and if they have a kid, they happen to be under 10-year-old or something, and if it is a 4-plex or 8-plex or 6-plex, something like that, or 12-plex, then you have to make everything ready in the whole building because there is a kid involved with the tenant. So you have to kind of repair the whole building for one tenant. Paint here.
Oh, you mean like some of the safety protections?
Safety protection thing, yeah. But if they don't have kid, then it's okay. They just look at that particular unit. But if they have a kid, then you have to repair all those things that can be safety issue in the whole building.
Interior wise too?
Yep, hallways, basement, anything you have. The kid might be walking here and there.
No, just the common areas.
Yep.
No?
Just
the common areas.
Common area. Anything you have a common area, they all have to be.
Okay.
Yep.
So like if you had storage or something in the basement and you had cyclone fencing around it or something, and everybody had to have a lock. But
yeah, if you have common laundry and if the kids are going there, if there is cheap paint or anything that needs to be that hazardous or anything,
Oh yeah, the whole building has to be mitigated for lead.
Yeah, hallways, staircase, anything you have, windows on the hallway, they all have to be repaired because of that one kid. And that is kind of extra expenses right there. Some of those things, I mean, if something is bad, they do, I mean, we have to take care of it. But sometimes they are looking at this little knick-knack here. There is a paint chip somewhere on the railing or somewhere on the staircase. They want you to go ahead and paint the whole thing.
Mm-hmm. Oh, yeah. Okay.
So sometimes it's not worth it, I mean.
Well, and if they make it mandatory, then like you say, you may have a building where you have some issues that are non-conforming to what Section 8 requires. All I'm saying about that is, it's so easy to say, well, we want to help people who are on these programs to make sure that in the city of Des Moines, it was mandatory. I think it's still mandatory. I haven't heard any change that you had to accept it. And there's city of Des Moines, and it might have been Marion and one other county. As Mary Davis is on here, I don't know.
Yes, I am. I'm sorry. I was in the middle of a text. What was that again?
Oh, just regarding the mandatory housing choice voucher program. Is the Cedar Rapids adopted that?
No, not Cedar Rapids, Marion.
Marion has?
Yes.
Okay. In fact, I think it might have started in Marion. But
it started in Cedar Rapids. We rejected in Cedar Rapids. We probably had the biggest turnout of realtors and property managers and owners that we've ever seen at a city council meeting. And so it got soundly rejected. But then they went to Marion and they were very quiet about it. What happens now is that you have to consider all and they couched it with, you have to consider all sources of income and including the choice vouchers, and they call choice vouchers as income, even though I've argued that's not income. You know, I can't take it to the bank. It doesn't work that way. From the standpoint of being able to use it in any other fashion, it's only usable in terms of that person's rent. So that's problematic. Unfortunately, what I do in terms of handling that, though, is rather than saying that I don't take the vouchers, I simply say, you're welcome to look at the property. However, I want you to understand that it is not approved for the voucher program. And most people at that point stop. Those that have vouchers just stop.
Oh,
So
because the property's
one.
not been approved for that.
The property has not been approved. It's not that I'm denying it. I don't deny it. I just, as far as accepting it, I just tell them it has not yet been approved or has not been approved for the program. And most of the individuals then who inquire just stop the process at that point. They don't even want to look at it if they know that it hasn't yet been approved. So that has worked for me. I really can't say about anyone else. I've never really heard anybody else talk about it.
Andrew, an easy solution to this would be you can you're only required to include garnishable income. That would eliminate all this bull crap.
Oh.
Well, and I understand, but the problem with that is we had a guy who was a veteran and is disabled. I think he has serious mental health issues. Because I don't think there's any physical disability, and he has been in the Des Moines Register and in the Cedar Rapids Gazette arguing that that anyone on Social Security, which is also not garnishable, should be allowed to apply for any property they want to apply for. Well, again, you still have the issue of, is your income sufficient? If it's not sufficient, then you don't qualify. I mean, you've got that baseline of 3 or 4 times the amount of rent to determine the income. You can accept any income, and I do. I accept any source of income. However, most times if they have Social Security, they don't qualify because they don't meet the minimum requirement. So you have to look at your minimum requirements.
Well, this is a plug again for using a tenant scoring worksheet and also it forcing yourself to adhere to it if you're going to have a stringent guideline that says there's, you know, like ours has, there's 4 different main areas where these are the knockout punches. And if you're going to apply for this property, this is what we're going to evaluate you on. And one of them would be source of income and then also the multiplier. You know, some properties are located in areas where you'd be really, really lucky to get 3 times rent from the people that are applying. They may not be able to afford that. They may have to live at 40% of their income instead of, what is that? Is that 40%? Maybe it is. 2.5 times is 40%.
Oh, yeah, 2.5 times in that area.
Yeah. And 3 times would be 33% of the rent. So let's say that the rent's $1,000, you'd have to gross $1,000, I mean $3,000 a month to qualify. But you can be selective on the type of property. You have A, B, C, and D types of properties. You can have different standards, but you must be consistent. You can't say, okay, yeah, I need to have 2.5 times rent one day, and then the next day you have an applicant, and then you're telling them it's 3 times the rent. That could get you into hot water.
I have a question. Can you hear me?
Yes. Yes, we can, Jeannie. Hi.
So I've always done the 3 times the rent, et cetera. But now that we're talking about people on Social Security, I was just kind of coming in to think about my mom who lives on her Social Security. She's got lots of money in the bank, you know, in retirement funds or whatever. But she doesn't pull that out. Now, do you just, so if her income, say, is $1,500 a month, which I think is what her Social Security is, something like that. But she has the sources, resources, I guess I'm saying. How do people handle that? Do you go ahead and say, oh yeah, she's got this money in the bank she could get to? I'm just curious how people handle that. So
You can always prorate the funds that they have in the bank and add that in as far as, you know, you can certainly say that funds that are in an account can be used as income. I try to remember to say resources, financial resources versus income.
okay.
Sure. So in lieu of a cosigner, you could say, well, we will allow someone to present proof of funds availability that
Right.
What
probably
about the wording on that? You know, if she would have to sell her home and move into someplace, I just was curious how people, those
well,
people.
it's just that, yeah, if you say, well, you know, okay, so you show me, you know, a principal insurance retirement account, an annuity plan or something like that that's paying or is available to you with cash. Well, what's there to assure me that I would be able to levy against that? You can't levy against the Social Security check that comes in. So, I mean, but whatever you're going to do there, I just say you want to be consistent. So, like, some people love to have people on Social Security because we already know 90% of them are mature adults. That's a huge, huge step forward when you're dealing with, you know, and another guy, there was a guy named Hannigan, I think was his last name. He specialized in what he called dingbat houses. They're little bitty houses that had one bedrooms. He didn't want all those extra people in the house. It would just then, and so he had like 17 one-bedroom houses, and guess who occupied them all? Widows on Social Security.
Yep.
You know, and he just said, you know, it's just sweet. It's like manna from heaven. The money just comes in. I go there, and the house is cleaner than where I live. You know, and they're so kind, and they offer me the coffee when I come in. You know, it's just like, you know, it was heaven. But it's a plan that doesn't work for everybody. This housing choice voucher one, I know it's going to be problematic for people. Some people think I can be very liberal at times. I can tell you on this one, I'm very conservative in that I think landlords should have the right to say, I don't need those extra headaches of an additional inspection, a mandatory 1-year lease. I can't evict without showing cause. And number 4 is, oh, by the way, once this house is on the program, if we bring somebody else to you, and somebody have to verify whether this is true, but I've heard this is true. If the house is on the program, you need to leave it on the program. If they find somebody else after this tenant disappears, you know, or vacates, then they have somebody else to put in there. You have to leave the house on the program. Why? Well, because they feel like they've been subsidizing you and your investment. Now, I get. We need to have somebody. That's what we need to do. Is we need to have a.
Yeah, and actually, I'm going to look that up because I just got hired by actually a landlord. She's local, but she now lives in Des Moines, and she's just had real problems with this woman who came in from Kentucky with a housing choice voucher, and she really can't work with her, and so she hired me to intercede. And I've been fairly successful so far. However, this woman is not completely cooperative, and you know, she's one who says, I want this, I want that, and is willing to file a complaint with Leeds Housing if she doesn't think the landlord is working quickly enough. She threatened me with that about a week ago when her furnace wasn't working, but she waited until 4:30 p.m. to tell me that just before Thanksgiving. So, you know, she believes that she's entitled, but she doesn't necessarily think she has to cooperate. And, you know, quite frankly, I'm not going to renew her next spring because she's just not cooperative. And so I think from the standpoint of that, I am going to talk to the local office a little bit about whether or not, if you're on the program, do you have to stay on the program, as well as just, okay, what do you want specifically for me to tell you with regard to this gal cooperating, because she's sure not doing it at this point. because I've had leased housing people tell me before, well, they don't want to know about the problems we have with a tenant. And I said, well, then why would you be surprised if we don't want to continue with that particular client? Yeah, it's just real bizarre. So my plan is to talk with them, because I've got another person I'm working with as well, and another company, and they're having real problems with her because she wants to have multiple assistance animals, and she doesn't bother to tell us when she brings a new one in. So it's a real problem as far as working with leased housing. I know some people like it, but I've not had good experience with it. So.
Okay. Thank you for that addition on that topic. Anybody else have any thoughts on the housing choice vouchers and what our position should be? Because like I say, I think some people, they're caught off guard when they hear Andrew say, I'm not in favor of it. It's happening all over the West Coast, Washington, Oregon, California. I do not see the inherent advantage to the investor, and we represent landlords and real estate investors here. We don't represent tenants. I do see that for those people who make a concerted effort to understand the program, and maybe they have housing in areas where it's more, well, they're going to have just a lot more applicants that have housing choice vouchers in hand. Well, then you want to make sure you avail yourself of all the education you need to have on the topic if you've never been on it before. So I think it can be very good for some people, particularly more out in the country, in smaller cities. You know, like they have the same thing with the agricultural vouchers for people and veterans. Okay, next one is check out lists being mandatory for move in and move out. I wanted to get this out to everybody to take a look at it first, but I think after talking to Christopher Warnock some yesterday, and where are we time-wise? I got to look at my watch here.
Yeah, we're getting there.
2 minutes, yeah, a couple minutes. We'll have Christopher on. So the thing is, we have somebody out of Iowa City, Johnson County, that's proposing a mandatory checklist for move in and move out for landlords and tenants. I was really surprised to hear Christopher be pretty strongly against it, but he gave some really good reasons for that. And one of them, it is fairly obvious, is that it's a nightmare to administer the whole thing. You could give a tenant a copy and say, okay, I need this back from you in the next 48 hours. When you move in, here's your keys, but I need this form filled out. You give them the clipboard, you get the form on it. 2 days later, you haven't heard a thing. A week goes by and you think, oh my God, you know, I'm never going to get that back, am I? And it's just another hassle. It's just another thing that makes your life more complicated. And yet we strongly believe that having a move in and move out checklist is a very excellent idea. But I think it should be personal. It should be your decision under the auspices of your standard operating procedures, not something the government dictates that says, hey, you're going to use this particular form. And can anybody else see this as being a bit of a nightmare?
That's what
and I think there's, go ahead.
That's what I see as the problem is if they mandate the form, you may want something on it that you've dealt with before that may not be on the list, or you might want to take something off and you won't be able to.
Yeah, just trying to standardize to a specific form that works for everybody. You're going to end up having an addendum on the form. You know, sometimes on the form that was furnished, it came from an apartment community. It's originating out of Johnson County because they have an awful lot of problems with landlords keeping the damage deposits when there really hasn't been any additional damage. Maybe the students tried really hard to keep the place up, and so when they move out, they're expecting to get a full rent deposit back, and many times they don't, and so they're just tired of it, you know. So they're thinking, well, we could force the landlord to give us a form that we fill out and say, okay, here's the condition of the property at the time we get it. It could solve some problems because we do have a number of landlords that come in and ask for us to help them with a money judgment, but they maybe don't have good documentation. They don't have photos of the before. They have the photos of the after, but they don't have good photos of the before. You know, this is what it was like when I let the property to this tenant, and now they're moving out, and oh my gosh, you know, they've just soiled this carpet so bad I got to replace the whole thing.
Andrew, I have used a
yes.
move-in checklist for probably 40 years. And the reason I do it is because I give it to them when they move in. And then later on, if I have to take them to court for money damages, I can pull out that, because usually there's nothing wrong with it. You know, they fill out the sheet. Well, half the time they fill it out, the other half they don't. But the ones you get back, 99% of the time, there's nothing wrong that they fill out. And then I have a question down there. Is there any other thing not on this list that needs attention? And of course, they always put no. And that way, when you go to small claims court, maybe a year or 2 or 6 months down the road, you can pull out this list after they just got done telling the judge how terrible the property was in and what bad shape it was in. And you pull out the list and you explain to the judge that that's not what they put on the move-in checklist. So that's why I do it.
I think, Andrew, this is Mario Fanu. I don't know if this would be another opportunity in terms of the way it's presented, but almost present them with a presumptive condition checklist. In other words, you as the landlord have gone through that property, that apartment. You've noted in what condition different things are. When they move in, they sign it. So you've got a signed copy, and then you tell them you've got 48 hours to return this to me. And if you see something different than I've noted on here, feel free to note that and turn it back in. If they don't turn it back in, you've at least got your list that notes the presumptive condition. And you've got something to go on down the road if you need to lean on that.
Could I jump in on this?
In other
Everybody
words,
can.
You don't have a hassle. You don't have to try and round it back up if they don't want to turn it back in.
Hi.
Oh, there's Christopher. Yay. Okay, Chris is here. Good, you found it. You found us.
Yeah, I was going to say if I could, I just make a little bit of comment about the checklist stuff.
Yes, you take over. In fact, wait, let me hold you for 1 minute. I want to see if we're done. I think we are. We got the haves and wants, unfinished business training. And so, yes, it's yours. Take control. This is Christopher Warnock, for everybody that doesn't know. He's an attorney from Johnson County. He knows his stuff, so listen fast. Good luck.
So, I'm a real big fan of evidence. And, you know, the checklist stuff, I think, is an amazing tool for landlords and for tenants as well, in terms of establishing the you know, what's going on with this unit. And, you know, obviously it'd be great if everybody on a move-in had pictures of everything, but that's a heck of a lot of work. And at the same time, I think it's great, you know, if you go through and you do a checklist, you've got it. If the tenant wants to respond to that, that's great. So I'm really all in favor of it as a voluntary tool. I have a lot of reservations about imposing it as a mandatory thing. But, you know, I think the main problem is the incredible paperwork burden that would put on landlords, and then the penalties that you have if you make a mistake with it, or you lose it, or you don't know about it. But I can't tell you how much I'm really in favor of checklists as a voluntary tool.
Thanks for watching. We hope this production empowered your business. Please like, comment, and subscribe for more great content. And don't forget to join us in person for powerful networking and priceless information at our next live event. For all event information, please go to our website.